Good afternoon, and thanks for tuning in and joining us today for our fifth employer webinar in our series. And today's webinar will focus on Colorado's new equal pay for equal work law. We have with us a couple of subject matter experts from the Division of Labor Standards and Statistics to help walk through what the law means, what compliance involves and entails. We received a number of questions submitted beforehand, so we'll leave time to walk through those and have our experts respond to those. Feel free to use the Q&A function to chat in a question during today's webinar. Everything is being recorded, and all questions being submitted will have written responses sent out to participants following the webinar. The entire webinar series from the Department of Labor and Employment is also featured on our YouTube channel. So look for that for today's episode, plus the previous webinars that we've had to date. So as I said, this is the fifth in our series. The next one we have in store for you for August is workers' compensation, specifically coming from our premium cost containment program. This is a program available to employers who demonstrate a commitment to workplace safety, are eligible for a reduction in their workers' comp rates as a participant in the program. So again, the date for that is August 25th. That's on your screen. An invite for that will be sent out along with all of the follow-up items from today's webinar. And again, as I noted previous webinars are available on our YouTube channel. Those topics include unemployment insurance fraud, what you need to know about your UI premiums, and a variety of other topics. September is Workforce Development Month. So September's webinar will focus on all of the services available to you as employers through the state's workforce system and other incentive programs available from the Department of Labor and Employment. Next slide. Real quickly about CDLE, we house a number of divisions and programs for employers to support employers through a variety of services and resources. We have a labor market information unit that can help you with your business needs and your outlook and help you with planning your workforce based on trends that we're seeing in Colorado's economy, a variety of training and recruiting tools available through our workforce centers statewide. As mentioned, workers' comp, we have some premium cost containment savings programs, a whole host of resources available to employers. Next slide. Specifically within the arena of incentives and compliance assistance, which again, that is what this webinar series is designed to provide to you, a number of services available through a number of our programs and divisions, public safety programs, workers' comp programs, as mentioned, unemployment insurance compliance assistance. We actually can deploy a team to your business and walk you through what's involved in an audit, but more importantly, what you need to know to comply with UI rules and regulations, wage and hour guidance, and support through our Division of Vocational Rehabilitation. We also have a number of employer recognition programs from our divisions. We have a Shining Stars of VR program recognizing employers who are committed to hiring people with disabilities. We have an apprenticeship program recognizing employers who are committed to hiring apprentices in Colorado. We also have a biannual workers' compensation recognition program, a variety of programs that will allow us to highlight and showcase all of the great work being done by Colorado employers. So with that, we'll go ahead and move on to our program, turning it over to Eric Yohe, Outreach Manager for the Division of Labor Standards and Statistics.
Thanks, Cher. Good afternoon, everybody. I have the easy job before I hand this off to our Senior Policy Advisor, Mary Donakai. Mary's going to talk about everything related to pay and promotion transparency, but it would be helpful for you to know before she does that where this information is coming from and where it can be found after the presentation. So we will be talking about the Equal Pay for Equal Work Act, primarily Part 2. There are two parts to the law. It went into effect January 1st, 2021, but it was passed in 2019. The two main set of laws and regulations we'll be referring to are the Equal Pay for Equal Work Act, Part 2 of that, and the Equal Pay Transparency Rules. Access to both of these documents and other resources and compliance guidance are available at the coloradolaborlaw.gov URL you see there. Once you go to coloradolaborlaw.gov, you can click on infos. Those are our fact sheets. We're up to about 14 infos now. One of them is on equal pay transparency. You can also click the box down at the bottom that says pay promotion transparency per the Equal Pay Act. The same information that we're going to talk about today will be found at that link as well. Next slide. Okay. Just a little bit more about the resources. We've actually set up a page solely for equal pay transparency, and the link is there and you'll have it available to you. It can also be found at coloradolaborlaw.gov and click on the box that says pay promotion transparency per Equal Pay Act. Talked about the statute and the rules. At that same site, you can find the text of both the statute and the equal pay rules. We also have additional compliance guidance, including that info number 9 that I talked about, and there's a summary fact sheet there as well. That's what we'll be talking about today. Those are what your resources are after the presentation. I will now hand this off to Mary Donakai, Labor Standards Senior Policy Advisor, for lots of things, but especially for equal pay transparency. Mary?
I apologize. I did the classic forget to unmute myself. Thanks for that introduction, Eric. We can go ahead. Thank you. This is the right slide. I would like to also thank everybody who's here today. We're delighted to have so many people in attendance, and this is really an extremely important part of what we do at the division is providing education and outreach resources. And we always love it when employers are interested in getting that information. I would hammer the point that Eric made a little bit more about the info number 9. It is a pretty comprehensive and detailed guidance document that includes both summaries of the statute and the rules, but also additional interpretation and information that addresses a lot of the questions that we've received, in the past 6 months of implementing the Equal Pay for Equal Work Act, Part 2. So I would encourage anyone who hasn't taken a look at that document to take a look at it. It's, I think under 10 pages and some pretty valuable information. So the Equal Pay for Equal Work Act, the requirements of the Act apply to businesses, individuals, the state, and other government entities that employ at least one person within the state. It also applies to nonprofits and churches. The only major exclusion is the federal government. And this is a bit different from some other Colorado labor and employment laws in that it applies to state and local governments. And it's also worth noting that it applies to employers irrespective of how many employees they have. If an employer has one employee in Colorado, it is covered by the Equal Pay for Equal Work Act. An employee is defined in the Act as anyone who is employed by an employer. So essentially, anyone who's employed within the state of Colorado, not by the federal government, is an employee as defined by the Act. And we can go ahead and jump to the next slide. So the substantive rights and protections provided by the Act are expressed in 2 separate parts. There's Part 1 and Part 2 of the Act. Part 1 addresses discrimination in pay and also using wage rate history to set compensation. Regarding discrimination in pay, Part 1 states that an employer cannot pay an employee of one sex less for substantially similar work, regardless of job title, based on skill, effort, and responsibility. And here the skill, effort, and responsibility refers to the factors that determine whether the work is substantially similar. And the statute sets out 4 factors that an employer can rely on to show that a wage rate differential that appears to be sex-based is permissible under the Act. And those 4 factors are systems based on seniority, merit, production quality or quantity, geographic location, education, training, or experience, but only when they are reasonably related to the work, and then travel if it is regular and necessary for the work. Part 1 also prohibits seeking or relying on an employee's wage rate history to set their wage. And this is designed to redress sort of baked in pay disparities that can follow employees across jobs. So if an employee enters the workforce and works for an employer that sets their pay at a lower rate due to sex-based discrimination, if a subsequent employer relies on that initial pay rate, even absent any discrimination by the subsequent employer, that lower rate that is the product of sex-based discrimination will follow the employee across jobs. So that's the impetus behind the prohibition on using wage rate history to set wages. Part 1 also says that an employer cannot ban employees from disclosing or discussing their wages. This was already the case under the 2008 Wage Transparency Act. We can go ahead to the next slide. Important thing to know about Part 1 is that it is not administered or enforced by our division. And there's a statutory reference there. That's the portion of the act that governs this. Our division can create a program to accept and mediate complaints and to provide legal resources concerning violations of Part 1. We haven't done this to date. We've really been focusing our efforts on educating Colorado employers and employees concerning Part 2 of the Act, which is the part that we are required to administer and enforce, and also on investigating complaints and supporting employers in compliance efforts. As I'm sure everyone knows, this law went into effect on January 1st, a little over 6 months ago, and immediately created requirements for the hiring process for essentially every employer in the state. And we know that implementing these new rules requires efforts from employers and attendant resources from our division to facilitate that. So that's really where we've put our efforts in the first 6.5 months of 2021. In terms of the remedies for a violation of Part 1, claimants can file a lawsuit. There is no requirement to first file with any agency, so they may file directly in court. And claimants may also still file a charge with the Colorado Civil Rights Division under the Colorado Anti-Discrimination Act. And CADA, the Colorado Anti-Discrimination Act, prohibits sex-based pay discrimination. Those are rights that existed before the Equal Pay for Equal Work Act. So it's those pre-existing rights are still in place and can be enforced by the CCRD. We can go to the next slide. So we're now moving on to Part 2 of the Act, which is the part that we actually administer and enforce. It has a few substantive rights and responsibilities. The first is here at 85201 subsection 1, and it is what we've referred to as the promotion or advancement transparency requirement. Requires employers to make reasonable efforts to announce, post, or otherwise make known all opportunities for promotion to all current employees on the same calendar day and prior to making a promotion decision. We'll get into more about what all of that means in just a minute. The second substantive responsibility and right here is what we've called the pay transparency requirement. And that states that employers shall disclose in each posting for each job opening the hourly or salary compensation or a range of hourly or salary compensation and a general description of all the benefits and other compensation to be offered. We can go ahead to the next slide. The final substantive right and responsibility in Part 2 is at 85202. It requires employers to keep records of job descriptions and wage rate history throughout an employee's tenure and for at least 2 years after the end of their employment. And those records are designed to be available if there's an allegation of sex-based wage discrepancy, and those records can help to determine if there is such a pattern of wage discrimination. Finally, at 85203 is the section, subsection 1, that gives the division the power to administer, carry out, and enforce all the provisions of Part 2 and to create rules for that purpose, which we have done. Statutory provision provides the remedies if an employer has violated Part 2. So the division may order an employer who has violated Part 2 to pay a fine of $500 to $10,000 per violation. I'll note here that the statutory language is may. Those fines are discretionary, and to date, the division has focused overwhelmingly on education and voluntary compliance and not assessing fines as authorized by this provision here. And we can go to the next slide. So those fairly sparse statutes we just looked at left a number of things to rulemaking and interpretation by the division. With regard to pay transparency in job postings, left the question of whether a posting is required. Can employers hire without creating a job posting that includes compensation and benefits? I left the question of what a permissible range of compensation is. How wide can the range be? And is it binding on an employer? Once the range is put in a posting, is that what the employer is bound to pay to whomever it hires? I left the question of which benefits have to be disclosed. With regard to promotion or advancement transparency, there's a question of whether the employer must provide notices of promotional opportunities only to those it deems qualified for an opening or to all employees, the contents and methods for providing that notice, and whether employers have any requirements for accepting applications or in the hiring process. Finally, as to both the pay and promotion transparency requirements, the division had to do rulemaking and interpretation regarding jobs, postings, and employees outside of Colorado. We have done this through our rules, the Equal Pay Transparency Rules, and our info number 9, both of which are available at the webpage that Eric showed everybody at the beginning of this presentation. I would encourage you to take a look at both of them, but we'll get into them in the next few slides as well. We can go ahead and move on to the next slide. So we'll talk first about the pay transparency in job postings requirement. That's section 852012 of part 2 of the Act. And that's the section that requires employers to disclose in each posting for each job the hourly or salaried compensation, or a range of hourly or salaried compensation, the benefits and other compensation. The very first question is whether employers are required to make such a posting. We've answered this at info number 9 on page 2, and the answer is no. The statute does not create any requirement that an employer make a job posting, only that it include compensation and benefits if it does choose to create such a posting. So employers have no requirement to create external job postings. We'll talk in a minute about the requirement to provide notice of promotional opportunity internally, but there's no requirement to do external job postings. In terms of benefits, which benefits have to be disclosed? At EPT Rule 4.1.1C, we've answered that question and said that all major benefits, so healthcare, retirement, paid leave, must be disclosed, as well as other benefits that have to be reported for tax purposes. Minor perks do not have to be disclosed. So access to a company gym or free donuts on Fridays, those are not considered benefits that have to be disclosed within the requirements of the Act. In terms of the range of compensation, we have defined this at EPT Rule 4.1.2. And essentially, the range of compensation in a job posting can go from the lowest to the highest pay that the employer believes at the time of the posting it might pay for that particular job. We have, however, recognized that things can change. An employer might have a change in financial position, or may decide to hire an applicant who is less qualified than was anticipated and train that applicant, or hire a more qualified applicant because it's going to be worth more money and pay more than the initial range. So because we understand that employers, there are a lot of reasons that an employer might end up paying more or less than the initial range. The rule specifically states that employers can ultimately pay more or less than the posted range, so long as at the time of the posting, it was a good faith, reasonable estimate of the range of possible compensation at the time of posting. So again, employers are not expected to anticipate every conceivable applicant and every conceivable scenario, just what seems likely and reasonable at the time of the job posting. We can go ahead to the next slide. The range does have to be specific to the job in the posting. This is addressed at EPT Rule 4.1.2, and info number 9 also addresses it. So in a job posting, the compensation must be for that specific job, not a department or category of jobs. There's one sort of narrow exception to this, which is if an employer legitimately might hire into one or another position from one job posting. So there's an example here where an employer is hiring an accountant and might hire a junior accountant or a senior accountant, depending on experience. In that case, the salary range would be the lowest pay for a junior accountant up to the highest pay for a senior accountant. But generally, the compensation included in a posting must be for just the one specific job that is the subject of that job posting. The compensation may be specific to a geographic location. There's two common ways this occurs. One is a multi-state employer posting a job that either could be performed in any state, including Colorado, it's a remote job, or could be performed, let's say, at one of 5 head offices and one office is in Colorado. In that case, the employer does not need to disclose the compensation it would pay in any other state, only in Colorado. And it can specifically say so in the job posting that there's a compensation range specific to Colorado. Employers may also wish to limit by location within the state. So a posting might specify one rate for Denver and Boulder, and then a different rate for other parts of Colorado. That, of course, is optional, but these are things that an employer may choose to do if it wishes in a job posting. Employers may also hyperlink or use a URL to link compensation and benefit information. This is limited to online postings. The idea is that if a prospective applicant has to be have internet access in order to see a posting, then they can follow a link or a URL to go somewhere else and get compensation information, provided the link identifies what it is. And this is one way that employers can streamline the sort of administrative burden of providing these disclosures. For example, an employer could provide the same hyperlink in every job posting and have that link go to a single page that lists compensation for every position it's advertising. So it can help to sort of streamline or alleviate a little bit of that administrative burden. Postings also don't have to include employer name or identity. This is a concern we've heard from a lot of employers that disclosing compensation could hinder their competitive ability to compete against other businesses because they've now publicly disclosed their compensation. In instances where this is really a concern, or where, let's say, a job posting might indicate something about a confidential project or any other reason that an employer wishes to have its identity withheld from a job posting, it can do so. There's no requirement in the Act that an employer be named in the position, just that the job be named or described and the compensation included. We can skip to the next slide. So a final question about the disclosure of compensation and benefits in job postings is the application to jobs outside of Colorado, to employees outside of Colorado, and to employers outside of Colorado. Anytime an employer has no Colorado employees, in this little table, you'll see column B there. Employers who don't have any Colorado employees have no obligations under the Act. By definition, they are not covered. And that remains the case even if they are advertising a job that is tied to a location in Colorado. So a California company that does not yet have any Colorado employees and wishes to hire someone in Colorado can advertise a job for that Colorado position without including compensation and benefits. For employers who do have employees in Colorado, the easy case is a job that's tied to a location in Colorado. The employer is a sports bar and they have a bar where they're hiring a waiter. That's tied to a location in Colorado. The employer has to include the compensation and benefits in that job posting. A second situation is where a job is tied to a location outside of Colorado. I realize that's my third situation in the table there. And this is a situation where a multi-state employer, let's say it's a company that has restaurants in Colorado, Arizona, and California. They are covered by the Act because they have Colorado employees, but when they're hiring wait staff for their Arizona restaurant, they do not need to include compensation and benefits in that posting because it is tied to a location necessarily performed outside of Colorado, and thus the division has interpreted that as being outside the scope of the Act. The final situation is a remote job. So this is a job that is truly remote. It can be performed anywhere, even if the employer has stated in the job posting that it may not be performed in Colorado. So even in the instance where an employer has said, we're hiring employees from anywhere but Colorado, if the job is truly remote, that job posting must include compensation and benefits. So this is a major clarifying point here, that an employer's statement that a truly remote job is not open to Coloradans or can be performed anywhere but Colorado does not take that job outside the scope of the Act. Compensation and benefits must still be disclosed in those job postings. And we do understand how someone could have perhaps interpreted our rules to allow such a carve out. We know that interpretation has occurred in the past, but that interpretation would be contrary to the statute, and it is therefore not lawful. The statute itself has no exception, really no exceptions for any jobs, and it provides that employers shall disclose benefits and compensation in each posting for each job. The division has found one very narrow implied exception to this rule, and that's for those jobs that have to be performed outside the state, and thus they're arguably beyond the reach of the Act. So that's the Arizona waiter, or if there's a multi-state criminal defense firm hiring a lawyer who must practice in California. Those are jobs that are tied to a location outside Colorado, and so the division has determined that they're outside the scope of the Act. But when an employer advertises a job as remote and performable anywhere but Colorado, that employer is confirming that the job can be performed anywhere, including Colorado. The employer is just mislabeling that job in an attempt to opt out of the Act. But this mislabeling really doesn't change the fundamental nature of the job, which is that it can be performed in Colorado, and the law does not allow for this kind of opting out. So these truly remote jobs that can be performed anywhere, and I'll talk on the next slide about some exceptions to that remote designation, but the truly remote jobs that can be performed anywhere must include compensation and benefits information, even if the employer has stated the job can't be performed in Colorado. And we can go ahead and move to the next slide. So this slide here clarifies a little bit what it means for a job posting to be truly remote. There's an example here, which is Danny Denver's Daiquiris. We have a little fun with the names, is a sports bar that has locations in Colorado and several other states. It's covered by the Act because it has Colorado employees. Danny's posts several positions. One is for a waiter in a Montana restaurant. This posting does not have to include compensation and benefits because the job cannot be performed in Colorado. They have to be in a Montana restaurant. The second is a remote, and it's in quotes because it is a primarily remote or work from home tech support position that must provide occasional support at the Bozeman, Montana headquarters. So these are positions where the employee will be primarily working remotely, but for some practical reason, some business reason, some reason tied to the nature of the job, has to be, say, within commuting distance of a particular office. The same would be the case if a company had, let's say there's a company that has headquarters in 3 states that are not Colorado, but has some employees in Colorado. If a remote worker must be within commuting distance of one of those headquarters, the job cannot be performed in Colorado. So even though it's labeled as a remote job, that job need not include compensation and benefits because it is necessarily performed outside the state of Colorado. The next scenario here is a remote tech support position. Same thing, except that it has to provide occasional tech support at the Boulder headquarters. That job is tied to a location. The location is in Colorado. That job will have to include compensation and benefits. And finally, the situation we were just talking about, which is a completely remote billing administrator position, where the job post states that it can be performed anywhere except Colorado. This is an instance of a job that really can be performed in Colorado. And so this posting does have to include compensation and benefits pursuant to Part 2 of the Act. We can go to the next slide. We're going to go ahead and move on to the promotion and advancement transparency portion of the Act. It's 85201 subsection 1. And this is the provision that requires employers to make reasonable efforts to announce, post, or otherwise make known all opportunities for promotion to all current employees on the same calendar day prior to making a promotion decision. The first question here is whether employers can provide notice of promotional opportunities only to those employees it deems qualified. The answer is no. It has to be to all current employees for whom the position would represent a promotion, which I'll discuss next. This is clear from the statute and also clear from the legislative intent. So the notice of promotional opportunity does have to be made to every employee for whom it could be a promotion. When is there an opportunity for promotion? We've attempted to answer this at EPT Rule 4.2.1. It's also addressed in some detail in info number 9 on pages 2 and 3. An opportunity for promotion exists when there is an existing or new position that the employer intends to fill. It's worth noting that a new position could be a position that really the employer is just creating what they consider to be a new job. But it also can occur when an existing employee has a change in title, authority, duties, or opportunities, and that's a material change to authority, duties, or opportunities that's sufficient to make their job a new job. This is intended to avoid a situation where rather than changing titles or actually, going through the traditional process of promotion, an employer tries to sort of circumvent the requirements of the Act by just adding duties, adding authority, changing the realities for one employee. And we want to avoid that and make sure that all employees are getting the notice of those promotional opportunities they're entitled to under the Act. A new position is not created when an employee has a change in pay, so that could be an increase or a decrease in pay, or just by adding a degree or certification to the end of a title. So if you add to the employee's title CPA or LCSW, that's not going to be considered a new position, and it wouldn't trigger the requirement to provide notice of a promotional opportunity. A promotion is a job that would be considered, or an opening that would be considered a promotion in terms of compensation, benefits, status, duties, or opportunities for any employee within the employer's workforce. And what matters here is whether the position would constitute a promotion for any employee, not whether it's a promotion or demotion or a lateral move for a specific employee. So in the instance where an employer has an employee and they are planning to demote that employee into a lower level position, if that lower level position would constitute a promotion if held by certain other employees in the company. So the employees at level 3, they're moving down to level 2. For anyone who's at level 1, that level 2 position constitutes a promotional opportunity. So in that circumstance, the employer must provide notice of promotional opportunity to all of the, we'll say in this scenario, the level 1 employees. We can go to the next slide. As to the contents of the notice of promotional opportunity, this is addressed at EBT Rule 4.2.2. It must include the job title, the means by which employees can apply, the compensation and benefits, and those are the ones that are required by Section 2012, that pay transparency section we just discussed. And the employer may include the required qualifications and an intended hire or promotee. So these are optional things that can go into a notice of promotional opportunity. One here is that an employer can state in that notice qualifications that applicants must have. That is a valid and permissible thing to include in a notice of promotional opportunity. And another thing is employers may wish to state in a notice of promotional opportunity who the intended hire or promotee is. This isn't required, but in situations where an existing employee is expected to be promoted into another position. We've heard from a lot of employers concerns about providing notice of promotional opportunity more broadly, both for the reasons of giving a false sense to other employees that they might be able to get this position that really is slated for or contemplated for one individual, and also that the individual who is expecting to get that promotion could be concerned if the promotion is now opened up to everyone in the workforce. I will say that this is what the division has done well before the act was in place. Whenever there is a promotion that is expected to happen or contemplated to happen, a notice is sent to every employee stating the nature of the promotion, what the new position is, and who is expected to fill that position. And it has a sort of dual benefit. One, typically, there are not a lot of applications for a position that is, has been dibsed by someone already in the workforce. It's, it's the milk in the fridge that has someone's name on it. There's typically not a lot of competition for those, but it has, the dual benefits of transparency. Employees now know who in the workforce is being promoted, what those career trajectories look like, and they're able to express interest in advancing their own careers. So it does have benefits in the experience of the division, just providing that notice to employees, even if they're not going to apply for that particular position. So I've included here a simple example that complies with the law. It says Joe Doe is recommended for promotion to senior accountant. Salary is 50 to 70,000, health insurance and 401k. Interested applicants contact SPO in HR. This little two-liner here is all employers need to comply with the requirement for notice of promotional opportunity. It has the title of the job, it's got the compensation, it's got the benefits, and it says how to apply. It also includes the optional provision that says, hey, this promotion is expected to go to Joe Doe, just to let other employees know, what to expect in that hiring process. In terms of methods for providing notice of promotional opportunities, basically employers can use any method that works as long as it reaches all employees. The employees have to be able to access the notice of promotional opportunity in their regular workplace. That can be online or in hard copy. A question we've received in the past is whether the employer has to provide the internet access themselves. The answer is no. If employees have, for example, a smartphone and are able to access those notices of promotional opportunity online, via email, intranet, job board, that suffices. The employer does not have to provide the internet access. Employees have to be told where they can find the postings. And then finally, if a particular method reaches some employees, but not all employees, the employer does have to use an additional alternate method to reach those employees. So for example, if most of the workforce has internet access, the employer could have email or intranet or online job board postings. But if it has some employees who are in, let's say, a rural location with no internet access, an alternate method must be used to reach those employees and provide them notice of those opportunities. Finally, there is a special method for regular and automatic promotions or hiring. This is an info number 9 at page 4. We received a lot of feedback from employers about promotions that occur automatically and very frequently. There are some workplaces where employees go from a junior to a senior, or an intern to a, official full title, whatever the job is, and it happens very regularly, which would be extremely burdensome in terms of providing notice of every single time those promotions are happening. And in particular, it can be difficult because if the promotions are happening automatically, the timing for notice could be challenging. So we have a interpretation that's included in info number 9 for hirings that occur at least once a month. So if an employer regularly hires into a specific position, it's hiring into that position at least one time a month. And then promotions also at least once a month that are automatic upon completion of set requirements. So these are promotions that occur when an employee completes a certification or a test or a specific number of service hours, not based on subjective evaluation of the employee's merit. So for these types of promotions, the employer can just provide a one-time notice of promotional opportunity. So for example, that could go on a bulletin board, it could go in a handbook, it could go in a static place on the employer's website. And it doesn't need to be changed, updated, recirculated every time that hiring or that promotion happens. Those postings do have to include the same basic information. So that's the title of the job or description of the job, the compensation or range of compensation, the benefits for that job, and how employees can go about applying. That information does have to be updated if it changes over time. So for example, if an employer puts a notice in a handbook for a particular type of automatic promotion, and then a year later, the compensation range for that position, the promotion position, has changed, the employer must update that information for employees. And it can do so obviously by providing an updated handbook, but a much simpler way of doing that is most likely to give employees a supplement, and that can be done through any means that reaches all employees. So it could be circulated by email, if that's an easy way for the employer to communicate with employees. It could go on the intranet, it could go on the regular job board, really just any method that will reach all employees to update that information. Let's go ahead to the next slide. There are a few narrow exceptions to the requirement to provide notice of promotional opportunities. These are at EPT Rule 4.2.5. One is for required confidentiality when an incumbent employee is being replaced and does not yet know that they are being replaced. When such confidentiality is really necessary to ensure continuity of business operations or protect the security of the business. In these circumstances, any employees who need to know about the vacancy in order to facilitate the transfer, all of those employees, of course, can be notified about that vacancy. And then if the employer chooses to notify any employees of the promotional opportunity so that they may apply. So if an executive is departing and the employer decides to notify other leadership within the company who may apply for that position, if it notifies one, it has to notify them all. It has to notify every employee who has substantially similar job duties. And that's measured the same way in part 1 It's sort of analyzed based on the responsibilities and then the duties of that job. So basically, every employee who's at the same level and has substantially similar job duties must be notified of that promotional opportunity if any of them are notified. A second exception is an automatic promotion after a trial period of up to 1 year. In this situation, the promotion has to be based on the employee's own individual merit or on the employer's business needs, and not a competitive promotion process. It also has to be documented in a writing. So that could be a handbook or the employee's contract, but it has to be documented somewhere in writing. And then the final exception here is a temporary acting or interim hire that is up to 6 months. Those do not have to be noticed to other employees. However, if and when they may become permanent, the employer does need to provide notice of that promotional opportunity to other employees. The final question here for the promotion and advancement transparency rules is whether they impose any requirements for receiving applications or any requirements in the employer's hiring process and who it ultimately hires. We have addressed that at EPT Rule 4.2 and also in info number 9. And the short answer is no. There are no restrictions on the hiring process, who is hired, what applications the employer receives and considers. This includes that employers, as we've discussed previously, can already know who a position is intended for. However, they cannot know the final choice, and that's based on the statutory language that says notice must be provided on the same day before the final hiring decision is made. Employers may state within a notice of promotional opportunity that applications are open only to those with certain qualifications. The employer can screen or reject candidates based on those qualifications. There is no set number of days before a hiring decision that notice must be made. Within the division, it's typically a few days often, and hiring is often shortly thereafter. But positions will often be posted and then close within a few days. Obviously, the amount of time that's adequate will vary based on a particular business, how it operates, the nature of the job, but as one example, a few days can be adequate. And there's no requirement that the employer receives or considers all applications, any applications, specific applications. The employer has complete discretion there. Go on to the next slide. This slide finally addresses how these promotion transparency requirements impact out-of-state employees, out-of-state employers, and out-of-state jobs. So the table here shows that employers who have no Colorado employees have no requirement to provide notice of promotional opportunities. And that's the same as with the requirement to include compensation and benefits and postings. Those employers simply aren't covered by the Act because they have no Colorado employees. I will also note that employees outside of Colorado are not entitled to notice of promotional opportunities. So a employer that has multi-state operations with locations in Colorado does not need to provide its employees in other states any notices of promotional opportunity. That's just not required by the Act or our rules. For those employers who do have Colorado employees, a job that is tied to a location in Colorado, that's the easy case. The employer must provide notice of the promotional opportunity to all employees for whom it could be a promotion, and it has to include compensation and benefits in that notice. For a remote job, truly remote, and could be performed anywhere, including Colorado, employers must provide notice of that promotional opportunity. They have to include compensation and benefits. And that's essentially the same logic as we discussed with the disclosure of compensation and benefits. Those jobs could be performed anywhere, including Colorado, and so they are within the scope of the Act. And then finally, a job that is tied to a location outside of Colorado. So this is a situation where you have a restaurant with locations in multiple states. Let's say the restaurant we talked about before that has Colorado and Arizona locations. They're hiring a manager for their Arizona restaurant. In that case, the employer must provide its Colorado employees notice of that promotional opportunity. So Colorado employees must be notified of this promotional opportunity in the Arizona restaurant. However, the notice does not have to include compensation or benefits information. And that's pursuant to EBT Rule 4.3, which does not require compensation and benefits in postings for jobs outside of Colorado. We can go on to the next slide. So we have, we've read the same news articles that everyone else has, and we understand that folks are concerned with the impacts of the Equal Pay for Equal Work Act and how compliance is with that act is going. And we have, in response to these concerns, which we share, done a significant amount of research sort of our own initiative. And what we found is that employers are overwhelmingly complying with the act and complying at an increasing rate. We've done one study of compliance by Colorado's 51 largest employers. It's 51 because we tried to find the 50 largest and there was a tie. So we ended up with 51. Obviously, this is an ongoing analysis and it's just of the first 6 months that the act has been in place. But what we found is that about 80 to 90% of job posts from these employers are complying with the requirements to disclose compensation and benefits. So Colorado's largest employers, the most successful employers, are overwhelmingly complying by including compensation and benefits in their job postings. We've also looked at remote job postings specifically. We've heard a lot of the concern that employers are excluding Coloradans from remote positions. So we did a random sample of more than 200 remote jobs posted on Indeed.com. These were about half Colorado employers, so employers who had some presence in Colorado, and about half of them were outside of Colorado. And what we found was more than 99% of the remote jobs did not exclude Coloradans. So the problem, while concerning, and the subject of, I think, a lot of discussion, in reality, from what we've seen, is really very nominal. The actual number of job posts that are excluding Coloradans from remote jobs is very small compared to the total job pool. And then finally, our own review of our experience in investigations. We have to investigate the complaints that we received alleging violations of the act. To date, we've received well over 100 complaints and investigated many of them. In every single instance where we have found a violation, the employers have fixed their non-compliant postings. So 100% of employers who we reached out to note that they had a posting that was not in compliance with the act, fixed it. And our policy has been and continues to be, anytime an employer voluntarily brings a post into compliance after a first violation, we will waive all of the fines. So to date, we haven't assessed fines against employers. Every single employer has complied. And this really is our critical goal. And what we're trying to do now is to continue this progress, which, every piece of data that we've looked at indicates that the state is making really strong progress towards complete compliance with the Equal Pay for Work Act. And our goal is to further that, not to issue fines. To that end, we're doing outreach like this webinar now, and we have more outreach and education coming. In particular, we, in our surveys, the employers who we have identified with non-compliant postings, we're going to reach out to those employers to let them know what the act requires and how they can comply. So those efforts seem to be successful so far, and we'll keep redoubling them. And we appreciate the efforts of all the employers in Colorado who have been working hard to comply with the act, it shows in the data. So thank you for making our job easier and doing what you can on your end. We appreciate it. Let's go to the next slide. I'm gonna go ahead and move on now to Q&A. We'll start with some questions that we received in advance of this presentation, and we're gonna then move on to some live questions. And I can see already that we have a few queued up, so I think we'll have a lively Q&A session. The first question here states, we don't have job titles or salary ranges. How does this affect our company? So as to the pay transparency requirement, employers don't have to have an external job posting before hiring. So if this particular employer chooses to do its hiring by soliciting resumes or working with a talent scout where it does not create a job posting, it doesn't have a requirement to disclose compensation or to disclose the job title. However, if the employer does create a job posting, it doesn't have to have a job title, but it does have to disclose the compensation and describe the job with enough clarity that it's clear what the compensation is for. I think that's not so much a requirement of the act as just a reality that if you post a job opening with only a compensation range and no description of the job, I imagine you'll have trouble getting applicants. So whatever description this employer is using when it posts jobs, if it does that, it can continue to do that. In terms of the promotion transparency requirements, I know the rules say the employer has to have a job title. I think it's fine if the employer uses a description of the position rather than a job title. The idea is just to let employees know what the position is. And then the employer does also have to include the compensation and benefits. Neither of these require a set salary range or salary scale. It just requires the employer at the time that it's making a job posting or providing this notice of promotional opportunity to say, what is it reasonably expecting to pay, and to include that information. We can go ahead and move to the next slide. This question says, we host a job board available for members and non-members to post their firm's openings. As we understand, the mandate for providing salary information and job postings is for employers. However, our organization could remind employers of the Colorado Equal Pay Act requirements. Can you confirm our responsibility as the hosting organization and further clarify the liabilities to users of our site? Can employers be in violation if they post to our website and do not include information as required by law? So I will go ahead and answer this part by part. First, info number 9, right on page 1, clarifies that entities that just share or repost the jobs of an employer. So that's the asker in this question, Indeed.com, a job board. They do not have liability under Part 2 of the Act or the EPT rules. The asker in this question does not have an obligation to provide information to employers about the Colorado Equal Pay Act requirements, but it may choose to do so. That could be a helpful, value add for those, for those employers. And as to the final question here, employers who cause a posting to be posted on a third-party website may be in violation of the Act and subject to fines if those postings do not comply with the Act. So anytime an employer has control over a posting, causes it to be posted on a job board or another website, if the posting is not in compliance with the Act, the employer may be liable. Let's go ahead and go to the next question. This question says, I inadvertently used an employment application that has salary info from the applicant after the January 1 new law. I have since updated our Colorado application to not ask for pay salary history. What do I do in the case where the applicant disclosed their rate of pay? The answer is, I believe, in 851022, that's Part 1 of the Act. And it says employers can't seek the wage rate history of a prospective employee or rely on the wage rate history to determine a wage rate. In this case, if the employer inadvertently sought this information, but did not use it to determine a wage rate, it does not seem to me that they would be in violation of the Act. I will say this with the major caveat, however, that the division does not enforce this part of the Act. It's in Part 1. This is our best interpretation, and I cannot guarantee it will be in line with how courts may interpret it, although I think it's a fairly straightforward one, I hope. Let's go on to the next slide. This question says, do we have to post the wage externally, internally, or both? Can we use a pay scale such as P1, P2, P3, and have the scale available upon request and not post the actual wage? I believe this question is mostly answered by slides 13 to 14 and 18. The answer here is the employer does not have to post the wage externally if they don't make an external job posting. If they make an external job posting, they do. The employer does have to disclose the wage internally when it does notices of promotional opportunity. Regarding the pay scale that is available upon request, that is probably not compliant. Employers can hyperlink or provide a URL to the compensation information in online postings, but it can't require prospective applicants to take additional steps. So requiring them to send an email or call a phone line to request the compensation information is not permitted. And that's covered in info number 9 at page 2 and EBT rule 4.2.2. Let's go to the next one. This is the final question that I'm going to answer substantively from an advance of the presentation. Is there a lawsuit about whether this law is unconstitutional? And is enforcement being held off until the case is decided? The answer is yes. Such a lawsuit was filed in late December of 2020. Enforcement of the law was not halted at any time. In May of 2021, the federal court presiding over this lawsuit rejected a request to issue a preliminary injunction. And for the non-lawyers here, that's basically an order that happens early in the case that would have halted enforcement of the statute and the EBT rules. The judge ruled against issuing an injunction. So enforcement has continued uninterrupted through 2021. And as of July 2021, the parties have agreed to dismiss the lawsuit. So enforcement has continued and will continue into the future pursuant to the statute and our rules. We can go to the next slide. We've got a number of questions here. We're short on time and want to get to some of the live questions. I'll give some quick answers here, but we've attempted to incorporate the answers to all of these questions into our presentation. So the first question is, as an employer who has employees in 22 states, does this require us to list salaries on all postings for jobs in states that are not in Colorado? I believe this is answered on slides 15 and 16. And the short answer is, if the jobs are really tied to a location outside Colorado, you don't have to list compensation. If they're remote or they could be performed in Colorado, you have to list compensation, but it's only the Colorado compensation. Next question here is, are we required to post salaries for jobs that are remote, i.e. the main office is in Iowa, but we may consider an applicant for Colorado? Again, we think that's answered on slides 15 and 16, and the answer is yes, you are. Is there an employee number threshold below which the company becomes exempt from the requirements of this law? Answered on slide 7, no. 1 or more employees is sufficient to bring an employer within the coverage of the Act. And then a final question here is a multi-parter. It says, so many employers are not listing the salary range in their job postings. What are the repercussions? Who calls them out? How do job seekers notify them? How is the state supporting this challenge and helping both job seekers and employers respect the law? Really good questions. I hope we've answered those in slides 5 and 6, which reference our complaint form, and also slide 21 regarding our compliance and education efforts and the compliance that we've seen thus far. With that, with that fun Q&A behind us, I know that was a little bit quick on those last couple of questions. I'm going to go ahead and turn the floor over to Eric Yohe to go through some of our live questions.
Thanks, Mary. And to be honest, I'm going to turn some of these back to you. A lot of these questions are the same, but I wanted to, it may have been answered, but there's some spins on some of the questions that we had in the printed Q&A. Very quickly, do elected official positions have to be posted internally with the wage range and benefits when they become vacant? So the question basically, is that a position for which a posting, an announcement must be made? What do you think about that, Mary?
Mary, you're on mute.
Thanks, guys. I was just chatting away. I was just chatting away in response to that question and fully muted. I think the answer is no, if it's truly an elected position. And the reason is that in the case of an elected position, there is not a hiring process. So the ability to, post a promotional opportunity or provide a notice of promotional opportunity is really, there isn't one. There's no open job and there's no one doing the hiring. So for those positions, no.
Yep. So the next question, thanks, Mary. So the next question is, may a company use a headhunter to reach out to a few potential candidates with specialized skill sets without posting the position publicly? So again, a position may not have to be posted publicly if the employer chooses not to post it. The question here would be, would they have to announce these as promotional opportunities?
Yeah, I think that's right. And in this case, yes, they would have to announce those as promotional opportunities just internally. So providing that notice to all employees within the company that for whom the position would be a promotional opportunity.
Next question, we've gotten I've received a few times, and we got it a couple times here, and I'm sure you've answered this before. Can you clarify a little bit more as to what would be considered a material change versus what isn't? I think you described it well, but if you could provide a couple more examples, I think that might be helpful to the audience.
Yeah, I don't know if I did describe it well. I think if we're talking about a material change in duties, opportunities, or I think authority is the other one that creates a promotional opportunity. I think it would be anything that's more than something that is nominal. If you see that change as advancing an employee along a career track, or it makes them now have authority over employees who they didn't have authority over before. It's a challenge because what constitutes that kind of material change can be so specific on the position and the realities of a business that it's hard to provide sort of a blanket answer. But what I'll offer you, and maybe I'll regret making this offer, is this is something that we'll take under advisement and think about whether we can issue some guidance to help clarify this question. And I would ask the asker of this question, in particular, if you have particular scenarios, situations, job changes in mind, we'd really appreciate if you could email us with those, and we'll try to provide guidance on those specific positions. But it also helps us have information so we can provide broader based guidance in the future.
Thanks, Mary. And I know we've provided that information. That information is on our website, but I'll go ahead and say publicly our email address as well. I'll say it slowly because it's kind of long. CDLE_labor. There it is, right there. Thank you. I won't say it out loud. Tracy took care of it for us. Let's see. So the next question, it's a good question, kind of a twist on how employers can make promotional opportunities available to their employees. Can we inform employees new positions are listed on our Indeed page, or must we inform them when a new position is posted?
Do you want me to go ahead and answer this one, Eric?
Yeah, if you don't mind.
Yeah, no,
that would be great.
absolutely. Yeah, absolutely. Well, if you tell your employees that the new positions are listed on their Indeed page, and then I think the question is, can the employees then just be expected to check the Indeed page regularly? Absolutely. You don't have to do anything else.
Okay. And I'm going to try to ask this question to sum up a few of these questions. They're kind of the same tenor. It's going back to the question about what is a material change. What I do want to make clear, because we haven't addressed this specifically. When an employer changes a pay range for existing positions, is that automatically a promotional opportunity? And for the most part, I believe the answer to that is no.
Nope. A pay raise, a change in pay range does not create a new position if it's individual or if it's for a number of positions.
Thanks. Okay, we've answered that. For the promotion stipulations that were discussed, how does this apply to employers that operate on a subjective 6-month promotion cycle? Would notice be required before each promotion cycle? I'm not sure we have enough facts there, but I think in general, yes, that would be the case.
Yeah, I'm not sure exactly what the subjective 6-month promotion cycle is. I think maybe this refers to the automatic promotions.
And by subjective, I think maybe they're saying the employer has the opportunity or can make the decision upon 6 months, but it's not necessarily automatic, but they will review at 6 months.
Yeah, if I would encourage the asker here to provide a little more detail. I'm sorry, I don't feel like we quite get the question, but we'd like to.
This one was interesting because it's new to me, Mary, so if you could help me with this.
Okay.
One. If an employer wishes to utilize an employment contract for hiring, can the employee discuss his or her compensation with another employee now with EPWA if they're working in the same capacity of employment within the company? Now, I know the bottom line answer this is the EPWA and another law, the Colorado Wage Transparency Act, an employer cannot prohibit employees from discussing compensation. I'm not sure that anything in this question would change the fact that employers can't prohibit employees from discussing compensation with other employees.
I think that's right. So the employer can't stop the employee from talking about their compensation. And if maybe part of the question is whether employees shouldn't discuss their compensation because of the wage rate history portion, that I don't think would apply to employees discussing their compensation. And in particular, it shouldn't restrict any discussion about compensation that isn't then used to set the employee's wage rate.
I'm going to skip to one that I think we answered, but then after we answered it on a slide, the questioner asked it again just to make sure. If we have ongoing openings for the same position, do we need to post those internally? If so, how often? I missed the answer. Can you answer again?
Definitely. This is an info number 9. I think it's page 4. And I think that's right. It addresses basically ongoing openings or regular hiring. So if you have a position, it's a big business, you hire into a specific position at least once a month. As long as you're hiring into that position at least once a month, then you do not have to do a posting every time you hire into that position. You can do the static posting in a handbook or on a bulletin board, and you don't have to refresh it and resend it and do a new one every single time you hire into that position.
Thank you. I don't think we're going to get to all of these, so I'm kind of picking and choosing these. There was a question that I can answer that's pretty simple. What are the penalties for pay discrepancies? Where can I find that information? That was on the enforcement slide. I don't have that slide number off the top of my head.
So
But go ahead.
Oh no, you go ahead.
So pay discrepancies and penalties, again, if you're talking about if an employer is found to have been in violation of Part 1 of the law, that's not something we enforce. That is something that would be handled through the courts primarily. I don't know off the top of my head if there's specific penalties that are prescribed in Part 1 of the Act. Do you know that off the top of your head?
I don't. I was about to look.
That's
but
fine.
this shows our lack of expertise in Part
Yeah.
1 because we just don't
Yeah.
enforce it.
Because I read this a different way, and so the penalties or fines for not following Part 2 of the Act, the pay transparency requirements, as Mary mentioned before, we have not actually ordered a fine yet, but they can be from $500, and it's always a may, it's our discretion, to $10,000.
I think that the section of the statute, if you look at the actual Equal Pay for Equal Work Act, I think the sections you'll want to look at to answer this question are 85103, and this is 8-5-103 and 8-5-104. I think that's where you want to look.
Cool. The next question I know I've received a few times, and I understand the concerns, and you've addressed this a little bit. We're purchasing another company. The current HR and sales manager are assisting with research for the acquisition of this company. At the time of the purchase, these two positions, HR and sales manager, would be promoted from working at one store to working at 3 stores and would be receiving a new title and pay. Do we need to post this? We have not yet announced that we are acquiring the company. So the question here is timing, I think, Mary.
Right. You do need to post this. It is not within one of the exceptions to providing, and this is when I say post, you'd have to provide notice of promotional opportunity. It is not within one of the exceptions. However, there are a number of ways that a situation like this can be handled. And one of those would be to have an interim position. And those interim positions do not have to be noticed to every employee. And I think it's also, it's possible that the employer may wish to have this be an interim position for other reasons as well. And then when the process is further along, and the employer has now announced the change in operations, then you could provide the notice of promotional opportunity before making those interim or temporary positions permanent.
Great. Just gonna pick a few more here. Any that we get to, we will provide the answers to after the presentation if we haven't provided the answer already. This is a question that it's an interesting question. Is there any requirement for retention of job postings, promotional opportunity postings once they're filled or completed? First thing I'll say there, I want to remind folks, because we didn't spend a lot of time on it, there are requirements in terms of retention requirements in terms of keeping salary history and position descriptions that are in Part 2 of the Act. With regard to the retention of the promotions themselves, is there specific, Mary, or is it just wise to keep to
I
make
think
to show that you're compliant?
I think what you said is exactly right. It's not required to keep it, but it might be a good idea to keep it in case someone files a complaint saying that you didn't provide notice.
Okay. The bulletin board question from Roseanne Mullis was answered earlier. Let's see. One of the ones I kept. Let's see.
I don't mind answering the first one there.
Okay.
The question is, how did we determine how to classify a company as a non-Colorado employer for our study? We did our best to dig into the records that are publicly available to see if the employer had any Colorado operations. And part of it was how the employer was classified on Indeed.com. But then we sort of also looked cursorily for any Colorado operations for the company. I will say it's not the most refined study, but that was our methodology. That was the best we could do with our time constraints. Hopefully we'll have better, more refined data at some point in the future.
Thank you. Another kind of a twist. We have answered this, but I can understand how this could be thought of differently. If I hire a new clerk and this would be a promotion for some of my current employees, I need to let my employees know there's a job opening, including pay or pay range and benefits and how to apply. If I post it in the newspaper, do I need to include the pay rate and benefits to the general public? So yes, if you choose to post publicly and you're a Colorado employer, you must provide the pay range and a general description of benefits.
Yep, nothing to add. That's great.
Okay, this is a good question. Please clarify who enforces Part 1. So in general, Part 1 is enforced by an aggrieved party filing a suit in court. They have a private right to action. However, they can also file a civil rights complaint with the Colorado Civil Rights Division. Those are the two ways someone can file a complaint or a claim that they've been discriminated against in violation of Part 1.
And I think I'll elaborate on that a little bit because I think this is maybe too complex for this point, but the claim that can be filed with the CCRD is under pre-existing law that always prohibited discrimination in pay. And what the Equal Pay for Equal Work Act provides in terms of pay discrimination is sort of a stricter standard. It has a specific definition of what a substantially similar job work is, that sets out what those factors are. And it also limits employers to those four factors that they can rely on to justify a pay discrepancy. And that was in the slideshow, I think maybe it's slide 7, but it's in the early part of the slideshow. So by filing a complaint in court under the Equal Pay for Equal Work Act, the employee can avail themselves of that more lenient standard or stricter for employers standard for pay discrimination, whereas filing with the CCRD would be under the pre-existing Colorado Anti-Discrimination Act, which has a slightly different standard. But saying it out loud, I'd say you should probably talk to a lawyer about it because it is a little complicated.
Thank you for elaborating on that. This is a question I've actually had this hypothetical. So if you could help us understand, Mary, I'd appreciate it. I think you discussed this, but I missed the answer. Some sites steal ads from Indeed, and I assume others as well. If they do not post all the information, is that the company's issue?
No. If the employer created a compliant posting and that information got scraped or copied by another party, and they omitted the compensation information, the employer doesn't have control over that subsequent posting, and they wouldn't have any liability.
Thanks, Mary. This one's pretty straightforward. I just wanted to clarify because the definition of employee under this act isn't always clear. I think we've done a good job of communicating the definition of employee, but the question is, does the act apply to 1099 employees? And for those of you who don't know, I believe what they're referring to is to people who are properly classified as independent contractors. Whether or not they use a 1099 tax form doesn't matter. It's whether or not they're an independent contractor. This law only applies to employees. So someone who is classified correctly as an independent contractor, this would not apply to them. Is that correct, Mary?
Absolutely.
Yep. Okay, we answered ongoing promotion opportunities. We've answered this. Can we list all jobs, pay benefits of all positions, how to apply if interested in all locations on one poster that we post in the break room or in the handbook? I believe that's true as long as everyone has access to either the break room or the handbook to know that this is available.
Yep. Yep.
I think this is similar, but if an employer posts a help wanted or now hiring sign, does that implicate the compensation posting requirements?
Interesting. I don't know what you think about this, Eric, but I would say no, because there's not a specific job. The employer is just indicating that they're sort of accepting applications. I don't think that constitutes a job posting. But I'm going to look at the rules and I may circle back to that one annoyingly in a minute.
Okay. Ongoing, we've done. No, there's no requirement that a job posting that displays multiple positions be separated into multiple postings. You can post multiple positions in one posting if you choose. That there's not a problem with that.
Yeah, and I would say the one sort of caveat is if they're different positions, you'd have to include the compensation range for each position.
For each one. Yep.
Yeah.
I'm just going through the last thank you for all of your thank yous. You're right, Mary has done an excellent job today.
This is my favorite part of Q&A is when people say thank you and other nice things. We really appreciate everyone's active participation. It makes this more fun and more productive.
And probably the question of the day, because I don't know the answer, I should know it off the top of my head. Does a seasonal employee fall under the Rule 4.2.5 exception? And can you restate for us, Mary, what that exception is and whether or not?
So the 4.2-5 exception is our, I want to make sure I've got the right one. Is it 4.2-5? Is it, I guess they're asking under all three. I suppose, I mean, potentially a seasonal employee could fall under, be a temporary hire, temporary acting or interim hire, as long as the employer does not think that it will be permanent, if they anticipate it would be just for the season. Yeah, I think that would fall under the exception for temporary acting or interim hires if it's less than 6 months. What do you think, Eric? Does that sound right? That's 4.2.5C.
Yeah, and I believe that's what they were referring to.
Yep.
Let's see, I want to make sure I hit a couple of these ones that you may have addressed, but we didn't get a question on. You said that an employee can hire at less than the pay range listing in the posting. However, if a posting lists a pay range of $14 to $21 per hour, but they hire someone at $13.50 per hour, can the new hire retaliate against the employer for hiring at less than what was stated in the posting? Now, retaliate, I'm assuming the employer means they can file a complaint. Well, an employee can file, a party can file a complaint. However, if the $14 to $21 per hour pay range is found to have been posted in good faith, and the employer has a legitimate reason for paying at $13.50, then that likely would be compliant with the law. Do you agree?
Oh, definitely. Yeah, I mean, the question will be, the employer's good faith estimate of wages at the time. And as long as it was, a good faith estimate of what it would pay, then there would be no liability. And I know we've got a handful of additional questions. I promise we will answer them in writing, which I believe will be emailed or circulated to everyone who is here. We'll share these slides and also the recording of this presentation.
Yeah, this is a good time to end. Thank you for all your patience as we try to get all of the questions that we can, but we will answer the rest after this presentation. Sherry, did you want to say any final words before we go?
Thank you, Eric and Mary, both. You've done a fantastic job today. Such valuable content. This is the second webinar on this topic, so we know a lot of questions out there, and can certainly continue this series and provide more information upon request if you'd like to use the contact information on the slide. And then just a final note, again, slides, recording, and answers to questions submitted will be shared out with all participants. All webinars are available on CDLE's YouTube channel, and our next webinar will be on August 25th at 2 p.m. with a focus on workers' compensation. With that, thanks to our speakers and all of you for participating. Look forward to the next session. Feel free to contact us for additional questions, and we'll send follow-up in the next day or so. Thank you again. Have a great day.